Um, so, good afternoon, everyone. A very warm welcome to this inaugural meeting of our new LUCIS Keynotes lecture series. My name is Natal Dessing and I'm director of LUCIS. Before I pass the floor on to Professor Adriaan Beetner, who will introduce this afternoon's speaker and chair the session, I would like, as LUCIS director, to say a few words about our intentions and ambitions underlying this new series. The LUCIS keynotes take the place of the LUCIS annual lecture and the LUCIS annual conference. Our plan is to hold LUCIS keynotes 4 times per year. Each meeting will feature a lecture by an eminent scholar who has had significant impact in the study of Islam and society. These lectures not only will be a great way to draw attention to current research, but will also give Leiden academics and students the opportunity to meet these influential researchers, at least online in the current incarnation. You're most welcome to follow this afternoon's lecture, and I hope you will be able to join us for a virtual reception in the LUCIS Wonder Room afterwards. We will post a link in the chat column in the next later on, and I look forward to seeing you there after the lecture. You're most welcome to post questions or make comments in the discussion period after the lecture. You may type your contribution in the chat column, or if you like to make your intervention orally, you may raise your electronic hand and we will give you the floor. I'm very proud that we are kicking off today of what I expect will become a very exciting series of LUCIS keynotes. It's now a pleasure to pass the baton on to Adriaan Beetner, who will introduce today's speaker. Adriaan, the floor is yours. Adriaan, we can't hear you.
Okay, there I go again. Well, I was saying, Michael, I'm very pleased to have you here. I still remember meeting you for the first time at KIT when you were there to help prepare a proposal for a bigger research project. It was a fantastic proposal, I remember, but it didn't get granted, unfortunately, but we've been in contact ever since. And it helped me to discover your work. You're an anthropologist, but you're one of those anthropologists who manages to speak to a very broad interdisciplinary audience. You wrote several books, and they have been an inspiration to our PhD students, and actually much of the research that has been done at the VVI in the field of family law and Sharia courts in Indonesia has actually been directly inspired by your own work. So we're very grateful for what you've done. And then last year, you came with this new book, Sharia Transformations, Cultural Politics and the Rebranding of an Islamic Judiciary, which is one of the examples of how much it pays off to continue going back to the field once you started your research there, and to actually show what the longer term changes happening are. And it's actually, again, you're setting an example for the VVI program looking at family law matters in Indonesia, as we also intend to undertake such work. It's quite an important book. It has many important insights. It also sets a number of theses which other people will need to address. So it's also setting an agenda, I think. But it doesn't make much sense that I will be talking about your book, because that's what will be going to do yourself. once again, I'm very happy you're here and that you're going to be the first to speak in the keynote lecture series of LUCIS. I look forward to what you have to tell us, and the floor is all yours.
Okay, thank you very much, Natal, and also Adrian for the very generous introduction. And I want to thank also the LUCIS program for kindly inviting me to share some of the material in my newest book with you today. Special thanks finally to Tineke Royakers and Petra de Bruin for help with logistics. It's a great pleasure and honor to be in the company of esteemed faculty, students, and others, both in Leiden and beyond. My only regret is that for obvious reasons, we have to communicate with one another at such a great distance. My goal today is twofold. First, to share some of the insights and arguments I developed in Sharia Transformations, which was published last year by the University of California Press. And second, to do my best to respond to questions and comments in the Q&A. I've included an image of the cover of the book, which shows what I refer to as the new Sharia Courthouse of the Federal Territory of Kuala Lumpur. The building was completed in 2011 at a cost of 96 million ringgit, about $30 million US at the time, replacing its Art Deco predecessor, which was built by the British in the 1930s. In architectural terminology, the new building is commonly glossed as late or postmodern Indo-Saracenic revival. Ross King, who has written about architecture and design in Malaysia and elsewhere in Southeast Asia, has noted that the building incorporates motifs reminiscent of iconic architectural design in Uzbekistan, Egypt, and Iran, much like the Putra Mosque in Putrajaya. He notes, in addition, and I quote, that there is nothing identifiably Malay in styling, end of quote. I would add that the eclectic but encompassing and in some ways pan-Islamic design of the building is congruent with Malay political and religious elites' strategies to situate Malaysia at the center of global Islamic banking and finance, whose assets in 2021 amount to roughly 2.4 trillion US dollars. A quick look at the table of contents of the book. I'm assuming people are seeing the same slides I'm trying to show. Is this the table of contents of the book? Yes, Adrian, you see it? Okay, great, sorry. A quick look at the table of contents of the book gives you a sense of some of the project's conceptual framing and some of my chief concerns. One point to emphasize is that I approach Malaysia's Sharia judiciary as a global assemblage. I used the concept of assemblage, drawn from Deleuze and Guattari, Latour, and others, in lieu of concepts like system, structure, or institution, for a number of reasons. I will mention two of them. First, I want to highlight the disparate nature of its components and their variegated provenances. These components include, most obviously, various aspects of classical Sharia law relating to marriage and divorce, for example, in addition to British common law, which is the source of almost all procedures in the Sharia courts. Other components of the Sharia judiciary include a Japanese, okay, that's Japanese, not Javanese, a Japanese system of management and audit known as the 5 S's, which Sharia judges and other court officials draw upon to manage their caseloads and work environment. Also relevant are key performance indicators, referred to as KPI, and protocols drawn from the International Organization for Standardization, known as the ISO, that judges and others prioritize in their daily routines and decision-making. Many of the latter standards are drawn from the world of corporate capitalism, as are the present-day uniforms of Islamic judges. The second reason I find the concept of assemblage useful is that it draws attention to the fact that the Sharia judiciary is ordered in accordance with a number of different logics and is also changing in a variety of different ways. This is partly to say that it is moving in multiple directions simultaneously, some of which might be seen as mutually contradictory. More generally, as can be seen from the table of contents and the subtitle of Chapter 2 in particular, I discuss what I refer to as the new punitiveness that we see in the Sharia courts. I interpret this as part of a globally widespread turn associated with neoliberal globalization that scholars variously characterize as punitive, authoritarian, illiberal, or conservative. One of the ironies I discuss later on today is that many women have benefited from this surge in punitiveness. This is partly because most plaintiffs in the Sharia courts are women and most defendants are men, usually plaintiffs' current or former husbands. Because men are more likely to be punished for neglecting or otherwise mistreating their wives, women have more leverage in the fields of domestic politics and might be said to be getting more justice from the Sharia courts than in earlier decades. This map shows a region of the world that is familiar to most members of the audience, but I thought it worthwhile to include for those who might not be familiar with Southeast Asia or Malaysia's precise location. You will see that Malaysia consists of two land masses, West Malaysia, there, if my cursor is working, also known as the Malay Peninsula, where most Malaysians live, and East Malaysia on the island of Borneo. West Malaysia includes 11 states, as well as the capital of Kuala Lumpur, formerly known as the Federal Territory of Kuala Lumpur. My research focused in part on the state of Negeri Sembilan, right there, in the southwestern part of the peninsula, and the district of Rembau, right there, in particular. The other focus of my research was Kuala Lumpur, commonly referred to as KL. Included here are some general comments concerning my orientation and approach, which is based on ethnographic fieldwork and archival study. I'm interested in what various scholars in the field of socio-legal studies refer to as the cultural logics of judicial process, as well as the history of judicial practices. I find Pierre Bourdieu's concepts of social field and juridical field quite useful. Bourdieu has noted that many social fields associated with religion, politics, law, education, etc., have their own relatively field-specific rules of play, cultural capital, and axes of contestation. They also have their own centers of gravity, which are grounded in arrangements of power and prestige within and beyond the typically contested boundaries of the field. In Malaysia, the juridical field is defined largely by the federal constitution, which is overwhelmingly secular, and by the dominant system of British origin common law, which is the law of the land, except within Sharia courts and Adat courts, which I will not be discussing today. The Constitution limits the jurisdiction of the Sharia courts to the nation's Muslims. Moreover, it further limits the latter court's jurisdiction to matters of family law and various sexual and religious offenses, such as adultery, not observing Ramadan, disrespecting Islam, and so on. Other matters, and all non-Muslims, fall under the jurisdiction of the nation's far more powerful and prestigious civil judiciary, which, along with the secular constitution, dominates the juridical field as a whole, as noted a moment ago. These facts help explain why many of those involved in Malaysia's Sharia judiciary view the procedures, the operational standards, and the regimes of management and audit associated with the nation's civil, that is, common law courts, as the gold standard. They must emulate if they are to overcome their reputation as backward-looking, second-class courts. Put differently, the Sharia judiciary must emulate many of the gold standards of the civil courts if they are to acquire more legitimacy, power, and prestige. More generally, my orientation requires attention to minute details of courtroom discourse and practice, both in the late 1980s when I began my fieldwork in Malaysia's Sharia courts, and in the period 2010 to 2018, when I resumed my research on that topic. As Anna Singh put it a few years ago, and I quote, "Big histories are best told through insistent, if humble, details." End of quote. I won't elaborate in my comments today on the details of my fieldwork methodologies or archival study, or what I refer to as how I know what I think I know. The slide before you gives information on such matters. Suffice it to say that I've spent more than 3 years living in Malaysia during the period 1978 to 2018. During most of that time, I was engaged in ethnographic fieldwork and archival research. The last two bullet points on this slide indicate that I've observed more than 300 hearings and motions in the Sharia and civil courts, 185 of which were in the Sharia courts, and that I conducted more than 60 interviews with officials in the Sharia judiciary. I should perhaps add that my contacts in the Sharia judiciary, who I want to say were exceedingly helpful and generous, shared quantitative and other information on many thousands of cases heard in the first 10 to 15 years of the new millennium. My research in the Sharia courts was in many ways much more formal than my earlier village-based research, as you might expect. In this photo, I'm speaking with the woman in the purple tudung or hijab, who at the time was in charge of mediation sessions, known as sul sessions, in the small town of Rembau. The formal introduction of sul sessions in the new millennium has been one of the major innovations that has occurred in recent decades. It is also one of the most explicitly Islamic and clearly branded as such. I will say more about sul sessions and rebranding later on. An important issue to bear in mind when talking about the Sharia judiciary and much else in Malaysia is the nation's ethnic and religious composition. Some of the relevant figures are contested. Some of them are likewise fudged by the government. Suffice it to say that the politically dominant Malays, virtually all of whom are Sunni Muslims, make up just over half of the population, 50 to 51%, depends whose figures you believe, and that Muslims as a whole make up roughly 60% of the population. I should perhaps explain that, as the slide notes toward the bottom, there are a number of non-Malays who are also Muslims living in the country, some of whom are citizens, some of whom are not. So the figure of Malays being 50 or 51%, if you take all of them as Muslims, which is the case, and add the other Muslims in the country to them, you get a Muslim population of roughly 60%. I want to turn now to a few of the changes I observed in the Sharia courts between the late 1980s and the period 2018, which is the focus of Sharia Transformations. I should first mention that I described courtroom dynamics in some detail in the late 1980s in a previous book, pictured here, which was published by Princeton University Press in 2002. My comments today about the situation in the late 1980s described in that book are necessarily highly abbreviated. We might start with the attire of the judges, then known as Qadi. In the late 1980s, Rembau's Qadi dressed much like the chief Qadi in the top row of this picture photograph, and in the photos at the left and center of the bottom row. The business suit attire of the chief Qadi in the bottom right row was soon to become the official uniform of Qadi nationwide. But This change had not yet occurred in the small town of Rembau in the late 1980s. What is most important to note about this slide, which is of the Qadi's chamber in Rembau in 1988, is that this is where all hearings were held. The Qadi never used the actual courtroom. Why? He felt that it might intimidate litigants. More generally, the hearings were relatively informal and geared toward mediation and compromise rather than adjudication. The Qadi used kin terms when addressing and referring to litigants. In other words, machi, pachi, kaka, etc., or auntie, uncle, elder sister, and so on, rather than formal designations such as plaintiff, petitioner, defendant, or respondent, which are the terms nowadays used instead of kin terms. In terms of seating arrangements, the Qadi sat behind his desk there, and the two litigants sat right in front of him there and there, right next to each other and literally 3 or 4 feet away from the Qadi. I often sat in that chair there at the end of the desk on the far left. Also noteworthy is that the Qadi was very interested in litigants' social origins, asal usul, and what kinds of persons they were, much as Lawrence Rosen and others have described for Morocco and other settings. Additionally, the Qadi usually avoided imposing sanctions on delinquent husbands and other defendants, and usually sought to maintain marriages, unless it was clear that the marriage could not be salvaged. From a bureaucratic standpoint, many of the hearings were what we might say, we might characterize as rather lax. I should add that almost all of the cases that came before the Qadi were civil cases, known as case mal, as opposed to criminal cases referred to as case janaya, and that roughly 2/3 of the plaintiffs were women who were seeking either maintenance, nafka, or the court's assistance with issues of abandonment, divorce, etc. Most of the defendants, as noted previously, were women's current or former husbands. I want to fast forward now to 2010 to 2011, which is when I resumed my fieldwork in the Sharia courts after working on other projects for nearly a quarter century. By this time, the nation's political and economic elites had embraced corporate capitalism and neoliberal globalization to a far greater degree than was the case in the late 1980s, and they had created a large, relatively affluent Malay middle class. This embrace of corporate capitalism and neoliberal globalization is evident in a number of analytically distinct social fields, including the juridical field that encompassed the Sharia judiciary. As one example, the black business suit with civil service name tag has been formally designated as the new uniform of Sharia judges, and the more traditional attire of these judges, shown in a previous slide, has been altogether abandoned. A related change is that the designation Qadi has been officially retired in favor of the term Hakim. You'll notice the term Hakim right there in the name tag in front of this judge here. In the Malaysian context, the latter term, Hakim, has long had as its primary referent civil court judges. In 2011, I asked a high-ranking official in the Sharia judiciary why this change had occurred. He responded by using the English language term rebranding, saying half-jokingly, "Oh, itu rebranding lah." This is when I began to realize that social engineers and brand stewards had undertaken far-reaching measures to upgrade both the images and the practices of the Sharia judiciary, which I should emphasize is under the direct control of the Prime Minister's Department. These measures involve aligning the Sharia judiciary with cosmopolitan norms bearing on corporate capitalist efficiency and rationality, as well as universalistic notions of justice, equity, and due process. The way these and related changes play out in the Sharia courts in places like Rembau and elsewhere is that judicial processes are nowadays much more formal and bureaucratic, much more oriented toward adjudication as distinct from mediation and compromise, and much more likely to involve lawyers who I never saw in the small courts in the 1980s. They are also far more punitive than in previous decades. Procedurally speaking, judicial processes in the Sharia courts are much more oriented toward British common law and various kinds of internationally prominent management and audit regimes. They are at the same time more Islamic in the sense that judicial discourses are far more likely to incorporate references to passages from the Quran and Hadith. Oops, sorry. One indication of the new punitiveness mentioned earlier is the presence in Sharia courts in small towns like Rembau of Sharia prosecutors who were never involved in cases in the late 1980s. Another is the presence nowadays of bailiffs, who likewise were not a feature of hearings in the late 1980s. More generally, criminal cases are far more common than they used to be. This would be expected in light of the recent criminalization of activities, such as divorcing one's wife without the permission of the court, that in former decades were altogether legal. I will address issues of gender in more detail in a few moments. In the meantime, I want to highlight additional instances of the rebranding process I've mentioned a few times. The poster you see on the left side of this slide provides an exceedingly clear example of one of the ways that political and religious elites are endeavoring to rebrand the Sharia judiciary so as to make it appear more congruent with universalistic notions of justice, equity, and due process. The text on the far right, for its part, elaborates on what is commonly meant by the concept of rebranding. I would draw attention to the last line of the text, which indicates that, broadly speaking, the goal of rebranding is not limited to enhancing a company's or an institution's market share of profit. It may also be oriented toward augmenting one's market share of power and legitimacy. This is clearly the case with Malaysia's Sharia judiciary. It remains to add that the rebranding of Malaysia's Sharia courts has multiple target audiences. One such audience is the nation's non-Muslims. Remember, that's roughly 40% of the population, who are very apprehensive, if not overtly hostile, to the expansion of Islamic law and normativity that has occurred in recent decades. Another target audience includes Westerners, East Asians, and Muslims from Saudi Arabia, Kuwait, and elsewhere who have invested heavily in Malaysia in recent years and decades, or might do so in the future. Yet another targeted group is Malay Muslims, including women and members of the civil judiciary, many of whom have a rather dim view of the Sharia courts and how they treat women, especially in comparison to their more powerful and prestigious civil counterparts. In the early years of the new millennium, the Sharia judiciary, the civil judiciary, and other government bureaucracies adopted a Japanese system of management and workplace practices known as 5S, or the 5 S's. This was part of a nationwide push toward bureaucratic efficiency, both in the Sharia courts and elsewhere. The Japanese and Malay terms appear in the bottom half of the 2-meter-high banner pictured on the left side of the slide. Over there, the English glosses can be seen in the orange photo to its right. Beginning around 2011, I saw much evidence of the 5S campaign in Sharia courthouses, both in Kuala Lumpur and in small towns like Rembau. These included posters, brochures, in-house circulars, and so forth. I also observed many staff wearing jackets, windbreakers, and shirts emblazoned with one or another 5S logo, both within and outside of their offices. This photo shows the headquarters, or nerve center, as I would call it, of Malaysia's Department of Sharia Judiciary, which is located in Putrajaya, the federal administrative center of the nation's capital, Kuala Lumpur. This is one of the many contexts in which the 5 S's and KPI, which again refers to key performance indicators, and other regimes of modern management and audit inform workplace organization and work practices, including, in some cases, judicial decision-making. It is interesting to note, though perhaps not all that surprising, that the modern workplace environment pictured here is more or less identical to corporate workplaces in much of the world. Among the many ways that the Prime Minister's Department and other relevant bureaucracies have sought to upgrade the professional image of the Sharia courts over the past few decades is to make them not only more efficient and streamlined, but also more friendly and welcoming, both in appearance and practice. One of the specific ways they have done this is by introducing introducing mediation sessions known as soul sessions. These sessions are geared partly toward allowing women to voice their particularistic claims and concerns in relatively informal contexts, which are overseen by mediation officers, known as pegawai sul, the majority of whom, unlike Sharia judges, are women. A more general point is that the introduction of sul sessions represents what Michel Foucault has famously referred to as a pastoral development. Such development involve forms of care, leadership, and governance, emphasizing beneficence, salvation, and the well-being of both the individual and the group as a whole. Foucault and others have noted as well that punitive turns and pastoral developments often go hand in hand. This is definitely the case in Malaysia. The formal introduction of sul sessions in the early years of the new millennium has been promoted as a specifically Islamic innovation that builds on Quranic injunctions to settle disputes through negotiation, mediation, and compromise. The Quranic surah known as An-Nisa, cited on the top right of this slide, is frequently highlighted in brochures and other material that is currently distributed in Sharia courthouses and, of course, online and in many other contexts. It is also important to note that sul sessions are seen in certain quarters of the Sharia judiciary and by various Muslim scholars as an Islamic antidote to the kinds of formal adjudication and lawyering introduced by British colonizers, which some Sharia officials and others see as incongruous with Islamic sensibilities and dispositions. And you can get a sense of this from the two quotes noted here on the right side of this slide. This brings me to an important set of questions having to do with women's experience in the Sharia courts and whether they are getting more justice than was the case during the early decades of my research. In order to address the relevant issues with some degree of precision, I'm going to paraphrase the text in the next couple of slides. So first, the slide here is entitled, Are Women Getting More Justice?, which is also one of the chapters, latter chapters of my book and an article I wrote in Law and Society Review a few years back. The more here is meant to be a historical reference, more as opposed to in previous decades. So let's first refine the question. If we compare the data from the 70s and the 80s and earlier decades with the situation in 2010 to 2018, can we say that women are getting more justice from the courts than previously? Now, this is despite some setbacks, some reversals, some backlashes, and so forth, which I am well aware have occurred, and I'm happy to talk about later. But my point here is I want to look at sort of a longer-term historical perspective and not focus overly much on the setbacks, short-term reversals, and so forth. Okay, so point one is women receive more timely and substantive responses to their legal claims than in times past, though delays still do, of course, occur. Many cases, the majority of cases tend to be resolved in about 80% of the time that it used to take, or even more quickly. Sole sessions, for example, are generally speaking, meant to be resolved in roughly 3 months, and a good many of them are, in fact. That is quite a change from previous decades when a 3-month time frame was altogether basically unheard of. Second, the courts are less tolerant of and more punitive toward husbands' behavior that transgresses Sharia law, bearing on men's treatment of their wives and children. Divorce via the talaq clause or repudiation clause, for example, outside of court, in other words, if one recites this outside of court, used to be altogether acceptable, though in some cases certainly frowned upon. Now it is a criminal offense punished by fines and or jail time. That's just one instance of the surge in punitiveness that I mentioned in the book and can discuss in more detail if anyone would like. The third point is women are benefiting from pastoral developments in the Sharia courts, such as the formal introduction of sole sessions, even as, and partly because, their current and former husbands are subject to greater punitiveness, as are Malaysians generally. The fourth point is that in practice, the grounds for a woman obtaining fasa or annulment have been expanded to include emotional and psychological suffering and conjugal strife, known as shikak, even though there has been no formal change in doctrine. In other words, the doctrine has not changed. What has changed is judges' interpretation of the relevant provisions. This is a very important change. Why? It's because fasa is the only type of divorce or annulment that it does not require a husband's cooperation or consent. In this respect, Malaysia differs from Indonesia, Pakistan, and Egypt, and a few other Islamic Muslim majority countries, all of which are more liberal on this particular issue insofar as they allow women more options to divorce without their husband's cooperation or consent. The fifth point is that women nowadays have far more access to information bearing on their legal options and rights with respect to marriage and divorce. There is much greater rights talk, as some people refer to it, in circulation now than previously, and women are much more aware of their rights. 6, due to the proliferation of groups like Sisters in Islam and other NGOs, women can nowadays rather easily enmesh themselves in networks of support to help them negotiate marriage, its dissolution, and the uncertainties that may follow. So, just to recap very briefly, if we consider the situation from now, 2010 to 2018, okay, we consider that period to the period late 70s, 80s, and previously, I make the argument that women are getting more justice than was the case previously. I do not work with a one-size-fits-all notion of justice, as should be apparent here. In other words, a John Rawlsian kind of definition. It just doesn't work for the kind of questions I am trying to ask and answer. Now, I don't want to appear Pollyanna-ish or overly optimistic about the dynamics I am talking about, so I need to register some exceedingly important caveats to the generalizations I have just made. First of all, none of what I have said thus far, or none of what I say in my book, is meant to suggest that women come to or experience marriage or divorce or the Sharia juridical field on an equal footing with men. Clearly, they do not. Okay, that's very important to note. But and this is my point, the situation is changing in ways that are generally speaking favorable to women, as long as, another important caveat coming, they embrace increasingly restrictive regimes of obedience and heteronormativity. Okay, so as most Malay women do, in fact. Women judged to be disobedient or nusyus, or to have transgressed heteronormative expectations, do not necessarily benefit from the changes I've outlined here and are subject to increased scrutiny, surveillance, delegitimization, stigma, etc., and formal legal sanctions. So I am talking about the vast majority of women, but I'm not talking about all women. I want to make that very clear. I should just add as an aside, although it's not just a parenthetical aside, that women who are involved, women who do not conform to heteronormative expectations, their experiences basically never come before the Sharia courts. Okay, so while Malaysia has passed some regressive, one might say, repressive, one might say, laws bearing on so-called tomboys and lesbians and so forth, those cases basically never come before the courts. In other words, if one looks at the caseloads of the courts, they barely constitute a blip on the screen, so to speak. But there have been a couple of well-publicized cases that do exist, in other words. Okay. So let me see here. Now, I need to also make another couple of important qualifications or expansions on what I've been saying here. One important clarification is that it's not just women who transgress heteronormative expectations who are subject to increased scrutiny and discipline. All women are arguably subject to more scrutiny and discipline than was the case during my early fieldwork in the 70s and the 80s. Now, I'm talking now about in Malaysian society, culture, political realms, the public sphere in general, more than I am talking specifically about the Islamic courts. Okay, although what I've said also pertains to the Islamic courts. One indication of the shift that I'm referring to is the sign pictured in the slide here, which is posted at the entrance to Kuala Lumpur Sharia Courthouse, which admonishes women to cover their aurat, those parts of the body that should not be seen, and to wear appropriate clothing. The red lettering of the sign indicates that women are entering a zone, spelled that way, Z-O-N, a zone or space where their aurat must be covered. Below this is right there is a version of a well-known hadith, which may be translated as the Malay version, the signage there, as indeed women are aurat. Each time they go out, Satan takes notice. Below the hadith on the right, the boxes marked with X's indicate that the attire that cannot be worn into the court, which includes short skirts, t-shirts, and sandals. The check marks on the left signal the attire should be respectful, clean, etc. One important point to note here is that I never, ever encountered signage or admonitions of this sort during my early research in the 70s and 80s. I should add, though, that there are various signs around the courthouses and elsewhere that admonish men to behave appropriately, as you'll see, to dress appropriately is what I meant to say. Whoops, sorry, as you'll see in a moment. According to Islam, men too have aurat, roughly the part of the body between the navel and the knees. But virtually all Sharia court and other public references to aurat focus on women. Specifically, Sharia court references to women commonly focus on women's dress, appearance, and bodily functions, such as whether or not they're menstruating or pregnant, how many times they have gotten their period since their husband pronounced one or more talaq, etc., thus either directly or indirectly alluding to their aurat. A noteworthy exception to my generalization concerning the more or less exclusive link in public discourse between aurat and femininity appeared in a directive issued by the state government of Kelantan in September 2013, which is the focus of the article in the English language newspaper that is shown in this slide. The directive proclaimed that, effective immediately, the injunction pertaining to covering or protecting one's aurat would also be applicable to male employees of the State Secretariat complex in Kota Baru, the capital of Kelantan, even when they were not at work. This was apparently because some of them occasionally donned inappropriate sports attire, running shorts and so on, when coming to or leaving their offices. Consider in this connection the large signboard posted outside the Chief Minister's office in Kota Baru, advertising that it is a zone menjaga adat. Okay, this is the sign here, pictured in this newspaper article, and that menjaga or covering adat is a command of Allah, which is right there. Menjaga adat adalah perintah Allah. This signboard shows, and as an example of appropriate attire, a Malay woman clad in a fashionable black baju kurung with red highlights, complemented by full red tudung, an outfit which shows only the front of her face and hands. Right there. To her left is a distinguished-looking middle-aged man, also Malay, clad in a black business suit and civil service name tag. The idea that covering a man's adat is best done with a black business suit was subsequently caricatured in cartoons that appeared in local media, such as the one from the Sunday Star, October 6, 2013, that consists of 3 frames. First frame, I mean, it's pretty obvious, I think, what's going on here, but in case not, let me just clarify briefly. The first frame shows a happy buck-toothed Malay man whistling a tune, clad in a striped sarong and ill-fitting sleeveless shirt that is rolled up, t-shirt, exposing a good portion of his bare belly, who is about to walk past a large, imposing zone menutup adat sign that looks something like a stop sign. In other words, this is he is entering a cover up your adat zone. The second frame depicts the same man, clearly alarmed and making a hasty retreat after seeing the large sign. The third frame portrays him smiling, but no longer whistling, now outfitted in a dark, somber business suit, white shirt and necktie, happily resuming his journey. One of the clear messages conveyed by this cartoon, by others like it, and by the new directives on male attire, is that earlier, quote, traditional Malay male dress entails a kind of nakedness that is an outward manifestation of inner backwardness, as Henk Schulte Nordholt has put it for the analogous Indonesian case. Now, there's much more that could be said about this snippet of popular culture, the historical dynamics to which it refers, and the myriad transformations that have occurred in Malaysia's Sharia courts and the realms of religion, law, and politics over the past few decades. I've endeavored to highlight a few salient themes in my comments today, all of which are fleshed out in much more detail that has in the book that has served as the basis of my discussion. So rather than trying your patience any further, I'd like to thank you for your attention and open it up to Q&A. Thank you.
Great, Michael. Thanks so much for a very insightful talk and many issues which certainly give rise to questions. So I would like to open up the floor. You can raise your hand, as was explained at the start of the lecture, or you can use the chat. So who can I give the floor? Nico Kaptein. Please, Nico.
Yes, thank you very much indeed, Professor Peletz, for a very interesting lecture. I thought it was very interesting what you showed about this contemporary architecture, that it has in fact no longer any local elements in it. And I was also struck by the fact that this male attire also does not show any local elements any longer. I mean, this is the ideal. So I was wondering, are there any discussions on this issue that people say, well, we should also indeed have particular indigenous Malay elements in our institutions, and so on and so forth?
Yes, very good question. So if I go back to the pictures of the judges, if you recall, I could probably show them. I'm not sure I can find them here. Okay, let's see. Okay, can you see the pictures of the judges that I just put back on the screen? Okay, great. So the only, quote, traditional Malay concession, one might say, to the attire of Sharia judges, for example, is the tongkol, right? The other traditional concession, if that's the best word, I'm not sure it is, which doesn't come through in these slides, is that judges are actually barefoot. Because when they enter their chambers, they do so, when they enter the courtroom, they do so from the carpeted chambers in the back. And like Indonesians and many other folks, they always take their shoes off before they enter such a space. So this judge here and this judge here, when I was talking to them, and so on and so forth, they were either walking without shoes or altogether barefoot as part of the outfit they were wearing. But there's not much pushback other than from no small matter, the opposition political party, well, one of them anyway, PAS, which still which is suspicious, so to speak, and sometimes dismissive of this particular corporate sort of attire. But at the same time, PAS has the same challenge facing it as do government bureaucracies and folks in the Sharia courts, which is that it wants to appear modern, progressive, and so on and so forth. And in Malaysia, this really means embracing global capitalism, being forward-looking, and so on and so forth. So perhaps you're familiar with a recent book that came out by Patricia Sloan White called, what is it called? Corporate Islam, I believe, is the title of the book. And she talks about the new Sharia elite. In other words, the management and business advisors who are, Sharia advisors. They're basically PhD-bearing, globetrotting folks, etc. And they all dress in corporate attire as well. So this is the direction that things are going. But I would also mention, I paraphrased a passage from Henk Schulte-Nordholz's article in the book on dressing Indonesia. I forgot the name of the book, actually. But anyway, you're familiar with it, I believe. He points out that, there are many, nowadays the wardrobe of Malay men, for example, consists of, golf outfits and corporate attire and, of course, batik shirts and sarong and so on and so forth. So it's really expanded, but this is the direction that it seems to be going. But generally speaking, yes, there is pushback to some of these kinds of trends, including the emphasis on formal adjudication and lawyering. So I mentioned in passing that some folks view what they call Islamic ADR, alternative dispute resolution, by which they refer to sulh sessions. They refer to this as a much more appropriate way for Muslims to resolve disputes. But that is not going to go very far, actually, because when it comes to whether non-Muslims can use words like Allah, or when it comes to issues like the Lina Joy case, most Malay Muslims, in my experience, are not interested in a negotiated or mediated settlement. They want a cut and dry adjudication that, no, this is, the provenance of Malays. If that answers your question. I'm not sure it does.
Yes, thank you very much. Thank you.
Okay, another question. I don't see any hands raised right now. Then I can chip in, because I have a question. What I find the most remarkable difference with Indonesia is what you were saying about nusyus, because you see that in Indonesia, the developments are quite parallel in many ways, although it seems that Malaysia is more advanced in the corporatization and the globalization of its judiciary. However, when it comes to nusius, it's in Indonesia, there are now even judgments where husbands are considered nusius, and where generally women are, women have to have gone very far to be considered nusius. So that seems to be really different from yours, from what you described. I was wondering whether you have any idea where this difference in development comes from.
That's a great question. And when I was reading, some of the work that you've done with Stein van Haus and his book in particular, which I draw upon I didn't talk about it here, but I do draw upon, and Jan Michel's book, of course, and Nadia Sonnenfeld's book, which are very important to my work, actually. But the thing about nusius is that it's often out there as a threat. But in other words, husbands and husbands' lawyers will invoke the threat of nusius. But what's interesting about it is that when you actually talk to judges or look at court cases, it's never really, there's no proof ever that a woman has been nusius. So the actual incidence of women being held as having committed nusius is just, generally speaking, not there. But I've never heard, so the case you mentioned about husbands in Indonesia, I've never heard of a case in Malaysia where a husband has been threatened with or convicted of nusius, even though it's quite clear to anybody who stops to think about it, Sharia judges, you, me, or anybody else, that much of the behavior of husbands who are, brought to court, who are dragged to court, so to speak, they have engaged in nusius by any standard definition of nusius. But the way it is interpreted in Malaysia is that it's a female offense. And, but again, the actual offense is never really there. It's more the threat of it, right? Okay. Well, but I can't really answer, though. The heart of your question is why in Malaysia you have this difference. I mean, why compared to Indonesia, why Indonesia will sometimes convict husbands of nusius and so forth. But that's a good question. I don't know.
Something to look into. Yeah.
Yeah.
Thank you very much. Next question is from Tolga Guneri.
Oh, there's a question in the chat. Okay, I'm supposed to look in the chat. Let me find out how to find the chat. Okay. I'm not entirely sure. Okay. Well, I see.
We can read out the questions in the chat later on. So don't worry. It's just if you see the button with the room chat, then you can see it. But I'll read it out later on. But if Tolga is now, Tolga is there as well.
Okay.
I'll read it out later on.
Okay.
Tolga, can you just ask your question?
I only.
Otherwise, we go to Jan-Michiel Otto.
Okay, I'm not seeing. Do I go to?
No, there's no question in the chat. We can't see it. So Jan-Michiel, perhaps you go first.
Oh, I do see now. That Petra put a question in there about the Qadi. Is there an Ottoman connection for this term? Is that Petra's question?
Yeah.
Okay, maybe I'll have to come back to that one.
Shall I?
Michiel, please go.
Okay. Michael, thank you very, very much. I really enjoyed the lecture so much. It's very interesting, and I think that even beyond the case of Malaysia, it's very interesting because there are larger trends that you obviously have sketched out and drawn, and the comparison, the comparison between recent decade and the 70s and 80s, I think, is very, very important. So many of the trends that you discussed confirm earlier research. There's one particular point you mentioned, which I also found very interesting. This is the new punitiveness that you discussed. And very recently, I've done some research on what is being called restorative justice. And this is a trend which has come up, as many trends in the United States of America, but more recently it has expanded throughout the world. And it's been promoted, for example, in Indonesia, to the extent that there is new legislation and new practice that in hundreds of cases, what you call the civil courts, the prosecutors and the criminal judges in non-Sharia settings are actually intensively promoting the type of informal mediation and encounters between perpetrator and a victim and so on and so forth. So I cannot imagine that the civil courts and the prosecution and the criminal law scholars in Malaysia are not also aware and affected by this trend. I know that much of it is still theory, and that the dominant culture throughout the world is punitively oriented. But it seems it's also hard to stop. So could you see this trend in the civil courts, and then, of course, it's Sharia courts will embrace it and say that it's Islamic, and it has always been Islamic. Restorative justice has been appropriated by many fake scholars. So is there anything familiar to you in what I'm saying about restorative justice?
Yes. Well, okay. So let me go back a step. It's a very important question. I guess what I see in Malaysia is a number of dynamics and developments that are moving in sort of different directions. So on the one hand, there is this greater punitiveness. So various types of behaviors which were legal and acceptable in times past are now criminalized, and the punishments are harsher, et cetera, et cetera. Okay, so that's one set of issues. Now, when we look at sul sessions, mediation sessions, that's where we see more of the emphasis on restorative justice or rehabilitative justice, or mediation, compromise, etc., of the sort that I think that you are talking about. And we see that in the civil courts as well. So the push toward mediation, which you see throughout the legal system as a whole in Malaysia, started a couple of decades ago. It draws heavily on Australian, European, American ADR, alternative to the famous pound conference that was held in Minnesota or somewhere a couple of decades back. That is where you see those trends. And I didn't emphasize this today because I didn't know about the time frame, if I'd have enough time. But sul sessions are now, mediation sessions, at least in the Sharia courts, are now mandatory for most cases, unless you have already gone to some kind of religious counseling. So in most cases, you have to go to a sul or mediation session first. Now, the motivations for that particular change are mixed. On one level, they want to, as with ADR movement generally, they want to clear the courts, unclog the courts from all these cases that they don't consider as important as big civil and criminal cases. Okay, so I hope I don't get off track here, but let me mention one thing. So Malaysia is a huge center, as you know well, for Islamic finance, banking, halal industry, etc. Ironically, all of that is dealt with in the civil courts. The Sharia courts have no involvement in that for the most part because it involves contract law. Yeah. So the Sharia judiciary would definitely like a big hand in all of that, right? They want to take over that. So I interpret, maybe cynically, maybe not, I interpret some of the push toward ADR as a way to clear the courts for the impending movement of Islamic banking, finance, etc., to the Sharia courts. Now, the other impetus is simply to give women a better shake. I mean, to give women a better deal, so to speak. If you cannot resolve your dispute in a sul session within 3 months, then in theory, it goes to adjudication and lawyers and such. Okay, I'm not sure this is answering your question. I hope it is, but let me just mention one thing that may not have been tied up in my comments previously. When I mentioned that KPI, key performance indicators, Malaysia is a bit obsessive about some of these audit regimes, actually. But I mean, so is UK and Australia and many places, including my university. But the way that KPIs sometimes figure into court decisions is that in sole sessions, everybody knows they're supposed to be resolved in 3 months. If a sole officer thinks that it can be resolved in 4, maybe 5 months, or she, it's usually a she actually, will prolong the case intentionally in violation of the KPI because they don't want it to go to adjudication and lawyers, etc., because they feel that is not appropriate or kosher, to mix metaphors, vis-a-vis Islamic sensibilities and dispositions. I didn't mention that how KPI figures into judicial decision making. Anyway, so that was a little maybe off the track from your question, but did I answer your question?
Very much so. Thank you so much.
Okay. Okay.
Thank you very much, Michael. That was really insightful. We now have Tolga's question as well here, which actually ties in with what Jan-Giel asked. And he is wondering to what extent there is evidence that Sharia courts in Malaysia are looking at and getting inspired by Sharia courts elsewhere. Is there a particular region or country where these trends are coming from, or do they arise from other internal developments? Now, you said a lot about the internal developments, but about the examples elsewhere. Could you add something about that?
No, very good question. Yeah, okay, I have to think about that for 1 second. Well, let me start by saying this. Hopefully I will remember. I do see this question in the chat now, in the room chat, so I can keep track of it here. When I asked Sharia judges and others about the sources of various innovations that I observed over the past couple of decades, I naturally assume, to me, anyway, it was a natural assumption that many of the innovations would come from Indonesia, because for obvious reasons, right? Among them, Indonesia being the largest Muslim majority country in the world, cultural affinities, it's right next door, etc. But I was routinely dissuaded from that view because Malaysia views its Sharia courts and its legal system more generally as much more sophisticated, much less corrupt, etc., etc. So I think the answer, so anyway, people generally said, no, we wouldn't be going for Indonesia. When I mentioned Iran, I was doing that somewhat tongue-in-cheek just to see what people would say. Oh, forget Iran, there's Shiites. We don't want to have anything to do with them. I think Pakistan and Egypt would be the countries that would be most relevant. But, again, when we talk about sole sessions or family law issues, they frequently look to Australia, to Japan, to New Zealand, to the US. But then they emphasize the Islamic roots of all this, right? So what's interesting is the scholarly and judicial discourse on ADR, most of it starts only about a decade or two back. And there's a real strong push to packaging this in Islamic and Arabic terms. So, for example, the term sul or sulu, sometimes it's pronounced or spelled. Most Malays have never heard that term. It's not in any dictionary that I have. I've collected dictionaries over the past 4 decades. I've got about 8 or 10. It's not in any dictionary I have. And it's, so the government and the Sharia courts have to explain to Malays, okay, where does this term come from? It's an Arabic origin term. It has deep traditions in Islam, etc., etc. But most Malays are completely unfamiliar with the term, which is why, when you look at the brochures about sul and about the rights of women in divorce and marriage or whatever, they go through always with the sole session brochures. They always have a introductory section which explains sul is an Arabic origin term, blah, 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 because Malays never heard of this term. So this is part of the rebranding, repackaging kinds of issues. I'm not sure I answered that question. But yeah, I would say, again, Pakistan, Egypt. But again, interesting to go back to Nadia Sonnenfeld's book on Kul in Egypt. The emphasis in Malaysia is not on improving Kul or Kulu laws, or tabus talak, as sometimes called in Malaysia, but the way they are making better provision for companionate marriage, basically, is by expanding the grounds for fasa, right? In Indonesia, according to Stein's work and your work and other folks, Mark Kamek, etc., the emphasis is basically seemingly on no-fault divorce, right? Malaysia doesn't have that, and it doesn't have the expanded grounds for cool that Nadia Sonnenfeld talks. So the innovation there is with respect to fasa. So in all those three cases, Indonesia, Egypt, Malaysia, you have three different Muslim majority countries trying to make provision for companionate marriage, but doing so with respect to different types of Islamic legal innovations, if that makes sense.
Well, it certainly does, and that was, I think, a great answer to this question. Okay, Tolga agrees, fortunately. So we're already we've already passed the time allotted to us. I don't see any other urgent questions now. So, well, let me thank you very much, Michael, for really a very stimulating talk. And I heard a lot of things which made me think, and I look very much forward to discussing them more at length with you. We should have a conference, including all the people you mentioned, a lot of whom worked in Leiden, but also Mark Kamek and others. I'll return the word now to Natal. That's a very Dutch expression, but Natal will get what I mean.
Yes, yes. So thank you again. So I take the opportunity to thank you again, Michael. Thank you very much for this very interesting lecture. Thank you, Adriaan, as well.